The next matter to come before us this morning is State of Ohio versus David Thomas. Mr. Kern, the appellant has waived. You have 15 minutes to present your argument regarding this case. We've read the briefs and are ready to proceed when you are.
Thank you. Again, I am Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the State of Ohio in this matter. May it please the Court, I hope to be very brief with this issue. I do not intend to use anywhere close to my 15 minutes.
Every time somebody says that, it's like they're asking for additional time.
Obviously, at the Court's discretion, if you have questions, please let me know, but my presentation will hopefully be brief today. There were a single assignment of error in this case, which asserts that the trial court erred when sentencing the appellant to a 16-year prison term, which is disproportionate to the convicted offense. And the gist of the appellant's assignment of error is that in an unrelated case charging a different offense for a completely non-similar course of conduct, including vehicular homicide and impaired driving and receiving stolen property of a motor vehicle, the offender only received a lesser prison sentence, and therefore the 16-year prison sentence in this pandering sexually oriented matter involving a minor and pandering obscenity involving a minor, both series of charges being felonies of the second degree, 10 counts of pandering sexually oriented matter and 16 counts of pandering obscenity involving a minor. Therefore, the sentence for those for 16 years is somehow disproportionate to a sentence on an unrelated offense. As I noted in the brief, courts have consistently held that in order for a proportionality argument to succeed on appeal, two things must happen. One, the argument has to be raised to the trial court below, otherwise it's essentially forfeited, and this court lacks the authority to hear arguments asserting new evidence for the first time on appeal. And secondly, the argument relies on evidence outside the record, which is procedurally improper under State v. Hill and State v. Ishmael. The other thing I'll note, that the 7th District held last year in State v. Jackson, the argument here tethers proportionality review for essentially child pornography by a group. The counts, pandering sexually oriented matter involving a minor, pandering obscenity involving a minor, groups those kinds of offenses and attempts to compare them for proportionality review to ag vehicular homicide and receiving stolen property. The 7th District in Jackson said that in order to conduct proportionality review, you have to compare sentences for the same offense. And the assignment of error in this case does not do that. There are no cases cited in appellant's brief or in the record to the trial court below comparing any potential prison sentence in this case with other child pornography sentences, whether that be from the 321 or the 322 pandering sexually oriented or pandering obscenity involving a minor. That is simply not done in this case. I know the court has read the brief and is familiar with the facts. If the court has any particular questions with respect to why the trial court thought that 16-year prison sentences were appropriate in this case, I'm more than happy to answer those questions. However, out of respect for victims and especially in light of the fact that the court reports its oral arguments now, I'd like to stay away from that if possible. But the other thing I'll note here is the trial court, page 16 of the sentencing hearing, noted that the defendant did not appear to have genuine remorse or accept responsibility for his actions. The trial court did not believe that any expressions of remorse were sincere. There were 26 counts in this case, 10 counts, as I mentioned, of pandering sexually oriented matter involving a minor, and 16 counts of pandering obscenity involving a minor. And the trial court determined that a 16-year prison sentence was appropriate. And for all the reasons identified on brief, and for all the reasons I identified today, the assignment of error the state believes lacks merit should be overruled. If the court has any other lines of inquiry or questions, I'm happy to answer those. Otherwise, I would respectfully ask the court to affirm. Thank you very much.
Thank you. For your presentations this morning, the court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website and the Supreme Court website. Thank you, Mr. Kern.